Hello, everyone, and welcome to Uncivil Law. And for today's story, we bring the Nick Rekieta drug-related saga to an end. As I'm sure many of you are well aware, Nick Rekieta was found with drugs in his house, a mixture of various substances, and he was charged with various crimes. And he pled guilty to a version of possession with other charges dismissed. And the conviction is itself deferred. So just to bring us up to where we are, there is a plea of guilty that has been accepted. He pled guilty, but the actual judgment of guilt has been suspended pending probation. And so basically, as long as he complies with the terms of the probation, the guilty plea will not be entered. This is a potential to never appear on his criminal conviction. So right now, for example, if you ran a criminal background check, it would not pop up as a conviction because he hasn't been convicted, because the judgment of conviction has been deferred. And if he ultimately is successful with what he has to do, there will never be a judgment. So it goes away. This is not unheard of, particularly for first-time offenses. And drug-related cases in particular, and even sometimes beyond that. So basically, sometimes you can get a pass under the right set of circumstances for basically a first offense. Lots of states have this. In this particular case, Minnesota has codified this in its statute as an option. So it's explicitly provided for by the court, as the court can do this if the conviction is of a certain scope. They can't do it for some convictions, but they can do it for other convictions. So this is an option that the court has, and that is the option that has been taken on. So we're going to review this in terms of what happened. So we're going to begin with the transcript of the hearing itself, which will illuminate all these things. We bring ourselves, hopefully for the last time, to the case of the state of Minnesota and the county of Candido High. In the case of state of Minnesota versus Nicholas Rekieta, this sentencing transcript came before the court, the Honorable Stephen Wenzel, judge of the district court, on April the 18th in Candido High County Courthouse in Wilmar, Minnesota. And then we have the appearances of the various people, and we will read the transcript of what occurred. The court. All right. The court will call court file 34 CR 24341, the state of Minnesota versus Nicholas Rekieta. Mr. Rekieta does appear with counsel here today. Chris Peterson, or Kristen Pierce, appears on behalf of the state. The matter is set for a sentencing hearing. There was a previous plea of guilty to count 1. Third-degree misdemeanor of 10 grams or more of a narcotic drug, to wit, cocaine in this case. The court did order a pre-sentence investigation report. The state's agreement does recommend the statutory stay of adjudication pursuant to law. The remaining terms of the sentence to be argued to the court and in the court's discretion. The state agrees to drop all other counts. The state agrees to dismiss 34 CR 24342 relating to his wife, so his wife charges go away, as well as an additional case involving another individual, namely the paramour. So part of this deal is that Nick falls on his sword and saves his wife and saves his paramour, neither of which have any further charges. Their cases disappear. So he is accepting responsibility, which I suppose is a very nice thing for him to do. So we'll give him credit for that, and that's what's happening. I don't have the other case in front of me, the defendant. It's 478, I think. What is it? The defendant. I think it's 478. Ms. Pierce, do you have that other file just so there's a clear record? Ms. Pierce, there is, Your Honor, I believe 2 court files, 34 CR 247 or 24 487 and 34 CR 24 342. The court, all right, have those been dismissed to date? Ms. Pierce, they have not, but I intend to file the dismissals after today's hearing. So after the sentencing is complete, the dismissals will be entered relating to his wife's and paramour's case. The court, all right, again. Francis Wright appears with Mr. Rekieta today. First, any errors and omissions with regard to the PSI you observed or updates, Ms. Pierce? No, Your Honor. Mr. White? Your Honor, we only have the objection to the recommended term of incarceration and then the duration of the probation as outlined in our sentencing memorandum. The court, all right, and we'll get to that argument in a minute. I'd ask that you just remain seated during your argument. Mr. White, okay. The court, we're recording and it helps to keep close to the microphone. Before we commence, as well, there's been a request received. It was yesterday, filed at 2:39 p.m., pursuant to Minnesota law, requesting to tape today's proceeding, or I should say record today's proceedings. Generally, if sufficient notice is provided, the court will allow that at sentencing. However, under the relevant statute, it's quite clear that the 7 days before commencement of the hearing or trial, there has to be written notice. So the written notice was not provided in a timely basis. So based on the untimely notice, the court is going to deny the request. So no video or audio recording of this, just the transcript. Any further discussion with regard to that? Ms. Pierce? No, Your Honor. Mr. White? Only, Your Honor, the fact that I was not made aware of that, nor served with that, the request by the attorney that made the motion. All right. And that's one of the requirements or need for notice. So both parties have noted of that, as well as to file any objections they may have. Also to notice the media coordinator and discuss those guidelines and information as set forth in rule. So the court is going to deny the request. Fair enough. All right, Ms. Pierce, your argument with regards to sentencing. Ms. Pierce, Your Honor, I've reviewed the pre-sentencing investigation. The relevant statute mandates a stay of adjudication in this type of case where there is a possession of third degree. I don't think it mandates it. I think it allows for it. So I think she misspeaks there, but I could look it up again. It mandates a stay of adjudication in this type of case when it's a possession, third degree possession charge with no prior felony drug conviction. Maybe she means that, yeah, I think it's still discretionary the way it's written, but I'd have to double check. We're asking for the probationary period to be up to 5 years of probation. The maximum term for probation is up to the maximum sentence for the charge. The maximum sentence for this is 5 years, which in this case is 5 years, and so that's why we're asking for 5 years. If he's compliant with the probation, he can be discharged. So the maximum sentence for third degree is 5 years, as opposed to the 20 years he was facing for second degree. So that was part of the deal. He got it knocked down a degree. So he was facing 20 years. And also, incidentally, second degree cannot be deferred. First and second degree cannot be deferred. Third and lesser degrees can be deferred. So part of the option here was, first of all, a lesser possible sentence. Second of all, the option to defer. But she still wants probation to the max. The maximum possible sentence is 5 years. Probation can be the max. So I want the max. I want all 5 years. That's a lot. She's asking for a lot. The request for community service is requested in lieu of fine. The sanction is intended to provide pro-social sober activity in the community rather than just a momentary monetary fine. And as far as jail time, Your Honor, it wasn't included in the formal plea petition, but it was part of our plea negotiations. And I believe that they did rely on the fact that the state would not be requesting any additional jail time in order. And so the state what I'm requesting, Your Honor, is that the court would impose 2 days of executed jail time with 2 days of credit. So the prosecutor says, well, we think our plea, although it wasn't stated as part of the agreement, which it wasn't, we think that our plea included no jail time. So since he's already served 2 days previously when he was arrested, how about a sentence of 2 days and therefore he gets credit for time served? So that's what the prosecutor's asking for. She's asking for no additional jail time because she thinks it's part of the plea. Okay. In a drug possession case, it's common to agree to no additionally executed jail time where there's been no pre-trial release of violations in this case. If the court deems additional jail time is warranted, we'd ask that you would impose it as part of a deferrable segment that will require a report date down the road, and if compliant with probation can be deferrable and not need to be served. Other than that, the state joins in the request to recommended as recommendations. So the sentence would be part of the conviction, which isn't happening at this time. So if you do impose a sentence, we would suggest that it only happen if he messes up. We don't think it should be served right away. Okay, fair enough. Other than that, the state joins in the request recommendations as outlined in the pre-sentencing investigation, Your Honor. The court. So with regard to, just so the record is clear, with regard to that jail segment, although it wasn't on the petition or mentioned on the record, that was the state's recommendation and discussion with counsel that you'd be recommending. Correct. So the state is doing the honorable thing, right? It wasn't previously mentioned in court. It wasn't part of the plea agreement. It wasn't part of the transcript. It wasn't. But she's like, that was our understanding. So we'd like to stick to that. Very honorable. Good on the prosecutor. Respect. The court. All right, Miss. I mean, she didn't have to necessarily do that, is why I say respect, because it wasn't part of the plea agreement as entered in court. She could be a dick about it, and she would be allowed to be right. She would be right if she were a dick about it, because it wasn't part of what was presented in court. It wasn't part of the formal contract of the agreement, right? The contract is the contract, and that was presented in court. So if she wanted to be a dick about it, she'd be like, yeah, we had some discussions about it, but it wasn't part of our formal agreement, so it's not binding on me. She could do that, but she's taking the high road. So respect. Miss Pierce, correct. All right, the court. All right, Mr. White, your position. Mr. White, my position is I agree with the state that we did, in fact, rely on the position of the state that there would be no recommended jail time and the formation of the plea agreement. I bet you do agree to that. Of course you do. As is outlined in the sentencing memorandum, which we filed earlier this week, a 5-year term of probation, which would, as Ms. Pierce has articulated, fit the maximum duration of the sentence. It seems a little bit heavy-handed in this situation, as Mr. Requeta has no prior criminal history, much less no prior felony conviction, criminal history at all, nothing juvenile, as the sentencing worksheet outlines. He's not wrong. 5 years is a lot of probation, especially for a first offense. He is not wrong. Even though the severity does rate it as D6, he has no priors whatever. He's abstaining in the community. Probably means something other than abstaining. It probably isn't the correct word, but that's okay. He has no objection to community service, so we think a brief return of probation is required under those circumstances. The court. All right, Mr. Requeta, your position here today. You have the right to provide a statement. You don't have to, but it's your right to provide a statement if you wish to. Yes, Your Honor, I'd love to. The court, you may. Okay, so yeah, the defendant does have the right to allocute during sentencing. It is his right to allocute if he wants. So would you like to provide your own exciting words, Mr. Requeta? Mr. Requeta would love to provide his own exciting words. Let's see what exciting words he decided to go with. The defendant, Mr. Requeta himself. Your Honor, I've always been called smart by my mentors, by my teachers, by my community members who I'm associated with. And after a while of making decisions that end up very, very well, you start to think that maybe you're kind of smart and you can control something, control the decisions you make and how that will impact people. I'm not sure starting with I'm really, really smart is necessarily the way to go, but okay. You can do things safely that aren't safe. What I did was I put my children through something I can't ever undo as a result of my decisions, not the decisions of anyone else. In the PSI, the pre-sentencing investigation, it laid out circumstances that I feel led up to what happened. But at the end of the day, it was me literally holding the bag. Well, in this case, very literally, bag of cocaine, yeah. It was my choices, and its consequences are borne by the people around me as much as they are me. I have to spend a lot of time working to repair that. I've broken trust with the community members, with family members, my wife and my children, and with the decision I've made for all that I want to say to the court, community to them, I'm very sorry. I mean, fair enough as far as it goes. I screwed up. It was my fault. I've hurt the people around me. I've impacted them. I've hurt my family. I've hurt my community. I've created real problems for everyone around me. So, I mean, fair enough as far as it goes. Respect. All right, the court. All right, well, a couple things, Mr. Requeta. There's a difference between being smart and wise, facts, and you have, in your past, a lot of things going for you. A very solid education, solid degrees, a good family, a good career, and you jeopardized pretty much everything here by your choices, which were completely unwise. Truth. And you know better, as your history in the legal field of how much you put yourself in jeopardy and your family in jeopardy by your decisions here. This is severe, or it's a serious offense in terms of public safety and community safety. This involves the, possession of cocaine. It furthers the drug trade, the illegal drug trade in this case by your involvement in it. And it wasn't residue or a small amount. So it's concerning to the court. Yeah, I mean, he might have been pleading to 10 ounces or more, but of course, the number he had is a bit more than 10. it would have technically qualified as second degree. Again, he could have dicked around on the margins because it was like only a half, and it was only like 1.5 grams over the line. So it's possible he could have dicked around and gotten it forced down as a matter of law, as I've said before, by any number of ways that this could have been, he could have argued about it because it was so close to the threshold. But I mean, either way, it was basically right on the bubble. It was right on the bubble for second degree. So he might have been able to force this down to third degree by operational law, but it was close. It was close. It was dancing on the edge. So yeah, there was that. And it wasn't residue or a small amount, so it's very concerning to the court. On the other hand, the state, who is in a good position to review and determine how things have progressed through your pretrial conduct, has determined that, number one, allowing for this plea to third degree is appropriate in a stay of adjudication. Yeah, I have no particular problem with that in the first instance, right? Again, he was right on the edge anyway. He was right on the edge. He might have been able to force it to third degree by operation of law. And he is pleading guilty and saving the time of the court and the prosecutor in the plea. So a degree down, yeah, I have no problem with that in the first instance. That's a very kind of common resolution. I thought he might even be able to do better than that in terms of a plea. He might have been able to actually get down to fourth if he had accepted responsibility earlier, or maybe even fifth. I don't know that they would have gone all the way to a misdemeanor possession. That's a kind of a big ask from, borderline second degree. It's like, how about misdemeanor possession? Or how about a misdemeanor offense? That's a pretty big ask. But he might have been able to get down to fourth or maybe fifth degree, or maybe even a misdemeanor if he had pled earlier on. But, not as much right now. And I'm still a little surprised he wasn't able to get down to fourth. I think the reason he's not getting down to fourth, incidentally, is because he's also asking for his wife's case to be dismissed and also his paramour's case. So that's part of the trade, right? So he's asking the state to do things they don't have to do. And so they might have been willing to offer fourth or maybe even fifth. But it's like, you also want us to dismiss these other cases against other people. Basically, we're going to make you pay for it. And so third degree, yeah, I have no particular problem with that as a resolution. That's a pretty reasonable resolution. Could have probably done better if he had accepted responsibility earlier, but we are where we are. And so, fair enough as far as it goes. Number two, you've made substantial changes since the time of the incident to warrant the state not recommending any additional jail. I was on the fence a bit about when reviewing it and whether or not I'd be ordering additional jail or not. I'm going to instead order it with deferral because there's some additional, requirements the court looks to other than just rehabilitation. The court, and tasked with that, as well as looking to public protection, deterrence, and public condemnation of criminal conduct. And that's from the sentencing guidelines. And part of the factors the court looks to as when it determines, sentences. Again, also, by the way, on the chart that recommends, the sort of the default, right, for this degree of penalty, when we looked at it before, the chart recommends a presumptive deferred. Or apologize, that was wrong. Let me restate. The chart recommends a presumptive no jail. Presumptive probation, according to the chart. Now the judge can, according to the chart, sentence up to a year in discretion, but there is a presumption of no jail in the sentencing guidelines. Theoretical max of 5 or theoretical max of 20 years. But even when he was second degree, the sentencing guidelines recommended no jail time because of his criminal history score. It was so good. So theoretical 20 years, but he was never really facing that. There was a presumptive, I forget what it was, 4 years, 5 years, whatever it was. But I mean, of probation. But yeah, I mean, that was, yeah. So, fair enough. So the court, and tasked as well as looking at public protection, deterrence, and public condemnation of criminal conduct. And that from the sentencing guidelines as part of the factors the court looks to when it determines, the sentencing. This will be a deferrable term. That means you don't have to serve it as long as you're compliant with probation. But that's another incentive for you to make sure you're following, the pretrial path, which you're indicating you followed since its incident. All right, here's how the court will proceed. You've entered a plea of guilty on count 1, third degree possession of a controlled substance in violation of law. That is a felony offense. And when I note the length of probation too, I do agree that up to 5 years is appropriate. That's a long time. This is a serious offense. It's a D6 offense. Right now, it does recognize that you don't have any priors within this contemplated length of probation. Really, the probation period is a maximum sentence of up to 20 years. That was just recently modified to 5 years. Well, I'm not sure that's necessarily correct, even the way I read the statute, but the judge might know something. But if it was modified in the statute, it was modified. So maybe there was an older version of the statute on which Nick committed him, because the right version of the statute, the right version would be the version at the time of the offense, not the version now. So if there was a change in the statute, we'd have to go look up the version as it then existed. So maybe the version as it then existed would have allowed for 20 years, or maybe the judge means as he was charged, it would have allowed for up to 20 years. I'm not quite sure, but fair enough. Although there's not a clear case that discusses whether stays of adjudication would apply, which discusses stays of execution or imposition, I do believe it's appropriate to follow through what the underlying principles of the statute are and to limit any probation to up to 5 years of time. Yeah, I think that might be required legally. So I'm not sure if the judge is necessarily right, but okay. All right, so the maximum penalty is 20 years. It would have been for the previous offense. I'm not sure that's true for the offense he's convicted of. I think the judge might be making a mistake. The maximum penalty is 20 years, $250,000 fine or both. That's a severity level D6 offense. You have a criminal history score of 0. Presumptive guidelines call for a state commitment of 21 months. That sounds vaguely correct. At this time, the court will not enter a conviction. So there is no conviction. He has not been convicted. He is not a convicted felon. It's deferred. Instead, the state will, or the court will stay adjudication and place you under probation for a period of 5 years. That is a long time, man. That is a long time. Under the following conditions, here are the conditions you have to agree that you have to do. Number 1, that you serve 30 days in jail, credit for two days served. You're to commence the remaining 28 days on August 1st, 2025, which can be deferred as long as you're complying with probation. You're ordered to complete 80 hours of community service. Whoa, sorry, I just scrolled. Let me find the where I was. Sorry about that. Hit the wrong button or something. Okay, where were we? All right, back to the conditions. You're ordered to complete 80 hours of community work service. You're ordered to follow recommendations of your discharge from Divine Hope Counseling, dated September 11th, 2024. And then the kicker, you're to have no use or possession of alcohol. Yeah, you're to have no use or possession of alcohol for 5 years. Or mood-altering chemicals except as prescribed, and to submit to random drug and alcohol testing as directed. 5 years, man. 5 years of sobriety. That's a lot, man. That's a lot. You can't use or possess alcohol or drugs for 5 years. That's rough, man. That's a rough go. I'm going to indicate that probation should be obtained a baseline as early as possible. You've been on pretrial release, so I want a baseline test so there's no, argument or indication that, you may have tested positive for something, that occurred prior to sentencing today. So I want a baseline so that we can see any differences from the baseline in the future. Nice thinking. The defendant, yes, Your Honor. Ms. Pierce, can you reach out to probation just to indicate when that would be available? You should contact probation after the proceedings here today, and they'll instruct you on that. If they instruct you to test today, you need to test today. The defendant, yes, Your Honor. The court, all right. You're ordered to cooperate with the cognitive skills program as directed by probation. Remain law-abiding. Sign and apply with the probation agreement and meet with probation as directed. So you have to meet with your parole officer from time to time. And yeah, they get to call you. They can bring you in for a meeting. It's a pain in the ass, man. It can be a real pain in the ass, particularly based on your parole officer. It can be a huge pain in the ass. You must obtain permission from probation for leaving the state. So for 5 years, if he wants to travel, he has to ask. If he wants to leave the state, he has to ask. That's, yeah. You have to follow all general conditions, including following all state and federal criminal laws, contacting probation when directed. You must inform probation within 72 hours if you've had contact with law enforcement, have been charged with a new crime, or if you change your address, employment, or telephone number. You're to cooperate with a search of your, this is also a bitch, you're to cooperate with a search of your person, residence, vehicle, workplace, property, and things as directed by probation. Warrantless searches. Warrantless searches for 5 years. If probation wants to search you, your home, your car, your workplace, if they want to order you to do a drug test, if they want to order you to do a hair or blood test, if they want to search your house, if they want to search your car, you have to say, yes, please. Yes, please. I'd like you to search my house and car. You have to say yes. Yes, please. I'd really like you to do that. Wow, geez. Yes, I'd really like you to test my urine and blood and my saliva and my hair. Yes, I'd really like you to go around in my house and look around. That sounds great. Please do those things, nice parole officer. You have to say yes. You have to say yes for 5 years, man. And they can just show up at your door. Depending on the rules, right? They can just show up at your door. They don't necessarily have to tell you. They can just knock, knock. I'm here to search your house. Boy, oh boy, I'd really like you to search my house right now. That sounds like fun. Let's do a search. If your parole officer wants to be a dick, they can make you be a dick, man. They can be a dick, man. They can be a bitch. How would you like to come in right now to my office? How would you like to come in and meet me at my office? How does meeting you at your house sound? Does that sound good? Boy, oh boy, it sounds great to me. Either way, your place, my place, all the places. Woof. It can be a rough go, man. Candy, Ohio County Correction Center, the youth assessor, and all their treatment and service providers are authorized to release and exchange information as they deem necessary. So corrections can share information, and the assessor can share information. Any treatment and service provider, yeah, you know HIPAA? You know HIPAA? Poof, it just disappeared. Boy, oh boy, I'd really like you to share my medical information with parole officers. That'd be nice, please. Please, any of these treatment or service centers, please, patient privacy. Yeah, I'd really like you to share my records. That'd be great. Please share my records with the nice parole officer. Woof. Can be rough, man. Can be rough, man. Any questions with regard to the court sentence? No, Your Honor. Mr. Wright? No, Your Honor. Now, I should bear out, by the way, that just because there are still rules here for probation, right? They can't quite do anything at any time. It's not quite that flexible, but it can be pretty close. So, are there still rules for probation? Yes, there are still rules, but not much, man. Not much, right? So it's not completely free-handed, but it's closer than not before someone corrects me. Before someone does actually technically, blah, blah, blah. Yes, actually technically, yes, they do still have to follow rules and procedures, but the rules and procedures that they have to follow in the end give them a lot of flexibility. So they have to follow the chart. They have to follow the flow chart. But it gives them a lot of flexibility. So it's closer to freehand for probation than not. But there are still some rules. But, yeah. The knock at the door effectively can come at any time. During daylight hours, at least, So maybe not so much at night, but during daylight hours, they can knock on your door. Effectively, they can get there. The court continues. You do have a red slip. Make sure you call probation following the proceedings here today. Will we have an order ready? We're going to have an order ready for here shortly. If you don't want to see in the hall, we'll bring that out to you in just a little bit. The defendant, thank you, Your Honor. The court, good luck to you, Mr. Ikeda. I hope you know this is a time you've been demonstrating much better choices in your life. I'm not sure why you chose, these poor decisions this late in life when you had so much going on at that period of time. It seems like, the temptation of, well, I don't know, if you just get out of control from your alcohol use or what happened. But you need to be mindful of that and, make better choices for your future so you can, preserve not only your chemical health, but also prevent any future jail time to yourself, okay? The defendant, yes, Your Honor. The court. All right, thank you. That will conclude the hearing. The defendant. Thank you. The court. I should note the remaining matters will be discussed. I apologize. I should note the remaining matters will be dismissed upon filing by the state. The state. That's right. And the state also moves to dismiss the remaining charges with respect to Mr. Rekieta. All right, so granted. End of record. So he's only convicted of the drug possession count, the count with relating to possession of firearms or ammo is dismissed. The count relating to child endangerment is dismissed. All counts with respect to Kayla are dismissed. All counts with respect to the paramour are dismissed. So that is the only resolution relating to these trio of cases, bringing us hopefully to the end of the saga, if fate is kind. And that is the end of the record. And then we have the reporter certificate. And then we have the formal order from the court. Let me readjust the margins so it looks nice and pretty for you. There we go. So this is the formal order from the district court. Relating to this, the order warrant of commitment. The count 1, drug possession, 3rd degree, possession 10 grams or more of a narcotic drug other than fentanyl. The relevant penalty, they say 20 years. Okay, maybe it was 20 years. Maybe I was mistaken. I thought it was a max of 5. But I mean, this is like, now it's on the order itself. So maybe it was a max of 20 and I was just mistaken in my head. I thought he was facing 20 years under 2nd degree. Now I'm curious. Now I have to look it up because I'm challenging my own memory. I have to look it up. Did they make a mistake in the sentencing order or is my memory faulty? Hold on one second. Minnesota drug statute. Hold on. What was it actually saying, the statute? Give me a second, please. Let's see. This is 3rd degree, right? All right. 2nd degree is, let's see, penalty is up to 25 years for 2nd degree. 3rd degree is up to 20 years. Okay, I was just wrong. Fair enough. I was wrong. I made a mistake. Yeah, apparently the difference between 2nd and 3rd degree is only a difference of 5 years, which doesn't seem like a lot to me. But I mean, it is what it is. So 3rd degree is 20 years or a fine of not more than $250,000. And 2nd degree is up to 25 years and a fine of not more than $500,000. All right, fair enough. My memory was faulty. Fair enough. Okay, I am corrected. So in any event, this has been stayed. So there is no conviction. The conviction is stayed. The plea of guilty exists. There is no conviction. The possession of ammo, user of controlled substance is dismissed, and endangering a child, permit, present, sale is also dismissed. The offense description, drug third possession, the terms of disposition is stayed. The sentence details as to count 1. Local confinement, defendant is sentenced to 30 days in the jail. Defendant is to serve 30 days. Credit for time served, 2 days. May be deferred if compliant with probation. The start date, theoretically, August the 1st, if he violates before then. Monitoring ordered. Defendant is placed on supervised probation for 5 years, monitored by Candy, Ohio County Probation. Conditions for probation. Defendant must comply with the following conditions. Do not use or possess alcohol or drugs except as prescribed. Random testing. Submit to random drug and alcohol testing as directed by agent and or law enforcement. Must submit a baseline test as soon as possible. Cognitive skill training. Cooperate with cognitive skill programming as directed by your agent. Remain law-abiding. Sign a probation agreement and comply with probation and meet with an agent as directed. Do not use or possess firearms, ammunition, or explosives. So no firearms for you for 5 years either. So you don't get your guns back. Very sad. Obtain permission from an agent before leaving the state. File all state and federal criminal laws. Contact probation as directed. Tell your probation officer within 72 hours if you have contact with law enforcement. Any contact, incidentally. If you're pulled over for a speeding ticket. Right? Tell your probation officer within 72 hours if you're charged with any new crime. Tell your probation officer within 72 hours if you change your address, employment, or telephone number. Sign releases of information as directed. So again, you know, all those privacy protections you have, not so much. right? You know that HIPAA? Not so much. If you need to sign a waiver, sign a waiver. You have to. You are required. Cooperate with search of your person, residence, vehicle, workplace, property, and things as directed by probation, and follow all recommendations of discharge by Divine Hope Counseling, ordered by the judge, also to perform 80 hours of community service, which no one cares, right? No one really cares. The 30 days is not the thing. The community service is not the thing. The conviction is the thing, right? Who cares if it's 30 days or not? No one really cares. You know, does it really matter if it's another 28 days? Probably not. The judge would probably even let him serve it like ever on the weekends or something. He probably wouldn't even send him for 28 days continuously when it came down to it, right? So like, I mean, I don't know that for a fact. I'm just guessing, right? So if he's like, you know, this is inconvenient, I only want to serve on the weekends, he probably could do that. Probably. So the 28 days isn't really the thing. No one cares. I mean, really, no one cares. Like the community service, 80 hours. What's 80 hours of community service? It's nothing, right? No one cares, right? What do you really care about? What you really care about is the conviction. What you really care about is the felony conviction. Because the felony conviction, of course, is a bitch. The felony conviction stays on your record forever. The felony conviction impacts your right to vote. It impacts, of course, your right to own guns forever. It also inhibits international travel. It also appears on any background check for any future job you might want to get. A felony conviction is a bitch. Also, it probably will pop up almost certainly as if a government agent runs your identifying information. So if you are pulled over for a violation, like if you're pulled over for speeding and they run your name, that felony conviction shows up. That might influence what the officer might do relating to that traffic stop. So it might make future traffic stops more inconvenient. It can make things a bitch. So the felony conviction is the thing, but for the moment deferred. But 5 years, man, 5 years is a long time to not reoffend. Commit no new offenses, commit no new crimes, don't drink, don't use alcohol. For 5 years, that is a long time. It's also worth noting, of course, incidentally, that just because he violates doesn't necessarily mean his probation will necessarily be violated. It isn't necessarily a guarantee. So he could theoretically do something and the judge determines not to violate him, right? So that's a possibility, lest, someone say, actually again. So it is possible that he could, test positive for alcohol or test even positive hypothetically for drugs that aren't prescribed, and the judge doesn't violate him. That could happen. But of course, you're at the mercy of the judge at that point. You're at the mercy of the judge. They can. And now you're just at their largesse. And how much largesse do you think they're necessarily going to have for you? How much do you want to play this game? Some judges are more lenient than others. How much do you want to play this game? It's a dangerous game to play. So could he violate once and not get, a conviction? Sure. Could he violate 5 times and not get a conviction? Possible. But, it's up to the judge's largesse. So you probably don't want to play that game, right? Even if they caught him traveling without permission, because that would be a violation of his terms, right? If he did travel, if he decided to travel out of state without telling his probation officer, that would technically be a violation. If the probation officer found out about it, for example, maybe he posted videos or images or photographs or someone else did or whatever, like that would technically be a violation, right? And also if he doesn't show up when probation wants him to, right? If they don't show up when he's ordered to, if he doesn't show up exactly on time, it's like you need to show up at 10 a.m. and he shows up at 10:30. That's technically a violation. So depending on how anal they want to be, depending on how much a pain in the ass the probation officer wants to be, depending on how exacting, right? If they want to go to the line, if they want to go to the limits of what they can do, probation can be a real dick. Not every probation officer is a real dick. Not all of them are real hard asses, but some of them are. And if they want to violate you because you showed up at 9:30 and not 9 o'clock, they can. If they want to violate you because you tested positive for alcohol, they can. And then the judge can sentence you. So how much of this game do you want to play? How lucky do you feel, punk? 5 years. 5 years. So, yeah, it's a pain in the ass. But that brings us to the end of the saga. And, I hope for Nick's own sake that he's able to comply with all this. He has made statements recently where he has indicated that he's not necessarily sorry for what he did. He's sorry for what it did to his family. He's sorry for how it hurt his family, but he's not necessarily sorry for the underlying conduct itself. He has made statements recently that indicate that he's not necessarily apologetic for the underlying conduct. What it did to his family, yes. What it did to his children, yes, but not necessarily the underlying conduct. And that's not necessarily suggestive of the strongest potential to remain clean indefinitely. If he's of the view of I like drugs, which he's made statements, at least in the past, that could be viewed as him saying, I like drugs. He's made statements that could be viewed along those lines. Then, denying himself for 5 years could be really challenging. It could be really, really problematic. So it could be a lot of challenge for 5 years. But, it's up to him to see how it goes. And then, the largesse of probation and the judge as you do. So that sort of brings us to the end of what I had to say about that. And then I will read some of your chats relating to this as well. One of the conditions was not streaming. That couldn't possibly be a condition, not to stream. That would violate his First Amendment rights. So no, the judge would never order him not to stream. No, that would be ridiculous. He has freedom of speech, and they can't take away his freedom of speech. That would be ridiculous. No, that is not a term. Yeah, keeping your nose clean for 5 years is not a cakewalk, particularly if your probation officer is a dick. Yeah, as to what happened with his kids, we don't know the answer to that question. We don't know the answer to the question. We don't know. We know that there was a presumptive positive relating to his kids, but it was unclear if there was a confirmatory test done. It was unclear in the previous transcript. So there was a preliminary positive, but not necessarily confirmatory positive. And we don't necessarily know what that was due to. So we don't really know. We don't have enough information relating to that. So it's quite possible that the lab, when they tried to do a confirmatory test, was unable to confirm it. So, I mean, we have no idea. What we do know is that it seems that is based on our best information. It seems that any child welfare related issues have been resolved. There doesn't seem to be any ongoing child welfare issues. So child welfare appears to be satisfied with whatever they determined in their own judgment. So that seems to be disposed of. So yeah, we don't have enough information to know if it was what that was due to. We don't have enough information. It's possible that his kid never had cocaine in the system at all. We just don't know. We just don't know. There's not enough information. Yeah, it could be that there was a contaminated glove and it touched the kid's hair. That's been suggested, right? They're supposed to wash it. That's part of the test of the confirmatory test. They're supposed to wash the hair to confirm it, but it could be. I mean, they did say metabolites in the transcript, but that might have not necessarily been accurate. Maybe it wasn't metabolites. Maybe it was something else. So yeah, we just don't have enough information. We don't have enough information about exactly what was going on. We haven't seen the drug test. We have no idea. We have reports as to what it was, and the reports may not necessarily be accurate. Maybe it wasn't metabolites at all. We don't know. Yeah, any prescription would be possible through a doctor. He can still get prescriptions through a doctor. So if he needs to take substances that are prescribed, that can still be done. That's fine. He can't take any non-prescribed drugs. So if he needs drugs for his ADHD, that's fine. I don't think there's any limitations on prescribed drugs. Not that I'm aware of. Blackbird says it wasn't weighed down to third degree. They reweighed it, lowered the grams. I don't know if that's true. Maybe it was true. Maybe it was knocked down to third degree because of a reweigh. It's possible. I mean, he was right on the edge. That's possible. Did he have to allocute? No, he did not have to allocute. He didn't have to say anything. It was his option. The judge doesn't seem very sympathetic. I tend to agree. Yeah, I didn't really expect 5 years probation. We were sort of thinking 1, 2, 3 was sort of the ballpark we were playing with when we were discussing this previously. 5 years is more than we contemplated. We collectively, and me included, we're not really looking at any jail time. We thought that, I said from the very start that jail time was unlikely. So the fact there's any jail time at all is more than my expectation. So the judge seems like he's kind of pissed. Yeah. So, yeah. Yeah, they will find a way to violate you if they want. Yeah, if probation really has it out for you, if they want to violate you, they probably can. Yeah. If they want to go out of their way to violate you, yeah, they probably can. If he breaks probation, does he have to do 5 years? No, he'd only have to do 30 days. 30 days is deferred. Yeah, his career as a whiskey reviewer is definitely over for the moment. That's true. If they had tested the kid and found the test was positive, Nick would have released the proof? Maybe. I don't know. I don't know whether he would or would not. I can't speak to that. I mean, I don't want to assume things I don't know. So I don't know whether Nick would necessarily release it or not. Maybe there's a reason he's not doing it. I don't know. So I don't know what I don't know, and I don't want to assume things. So, but fair enough. Nick himself said it was a test for metabolites. I don't know what Nick has said on this issue, and I don't necessarily know if that's accurate or if he was just quoting somebody. If they retested is wrong, Nick would have provided proof. He might well have done, but I don't want to assume it. Some meds can contaminate tests. That's possible. That's possible as well. That it wasn't really cocaine at all. That it was something else. That's also possible. Fair. Yeah, I don't know. But yeah, it's only a preliminary test. I don't know how good those preliminary tests are. If it was a field tests are shit. Yeah, so if it was a field tests are shit. If it was a lab preliminary test, I don't know necessarily what else might test positive for. Yeah, so it might have been not cocaine at all. That's totally possible. Yeah, I don't know. All right. And then, the only thing that's left is potentially maybe the body cam from Nick's house, because the case, of course, is finalized. There's no further investigation. Nick's case is disposed of. Kayla's case is disposed of. The Paramore's case is disposed of. So the only thing that's potentially left is the body cam footage. And I can't speak to the finer points in Minnesota law on this one. The way I sort of read it previously suggested, at least the way I had previously read it, and again, I'm going off memory, it's been a hot minute, but the way I seem to remember it reading was that it could be withheld as long as there was an investigation ongoing, but obviously the investigation's over because every case relating to it is closed. So I'm not sure whether or not the body cam footage can still be withheld relating to when the house was searched, or relating to when he was pulled over or stuff like that. I don't know the answer to that question. So the only thing potentially left is the body cam footage, but I don't know if or when that's coming out. I don't know the answer to that question. Oh yeah, and then also there's a possibility of another case ongoing. We're only speaking about that in vague terms because again, we don't know what we don't know. But there has been a suggestion that Nick has potentially violated the law with respect to accessing a computer when he's not supposed to. That's a separate case for a different day. And we don't know what evidence is relating to that. We haven't seen anything from the government relating to that. We don't know what kind of case they potentially have. Computer trespass can be a real bitch, depending on what exactly they charge you with under both state and federal law. The Computer Fraud and Abuse Act is a real bitch under federal law. If they want to charge you that way, it can be a real pain in the ass. But we don't have any information relating to this. We don't have any confirmation relating to it, and I don't want to relate facts that we don't know. But there has been a suggestion, from people that have suggested that there is at least an investigation relating to this, and maybe the investigation goes nowhere. Maybe there's not enough to indict. I don't know, but that could be another case for another day. I have no clue. So I don't know what I don't know, and so. It's possible, but we have nothing from the government yet. So at this point, it's basically rumor and conjecture. And we don't have enough information relating to that. Would the other case be potentially federal? It could be. It could be charged under both federal and state law. Yeah, both federal and state law make this illegal. Incidentally, the drug possession technically was illegal federally. So hypothetically, the federal government could charge him for that too. Also hypothetically, they could charge him under federal law with possession of a gun by a person under using a controlled substance. So, I mean, there are already federal charges they could charge him for that, but the feds tend not to get involved with rinky-dink stuff. That's not what their MO. They tend not to get involved with rinky-dink. They have better things to do with their time, usually. So I doubt Nick will catch a federal charge on any of this. That seems very unlikely. They have better things to do with their time than, nickel and dime shit, as one might say. Yeah. All right. Well, I guess that will bring us to an end. And Nick, if you're out there, I really hope that, you're able to fix the problems that you had in the past. And I hope that you're able to both solve the underlying issues, whatever they were, and also solve the drug problems and alcohol use issues. And I speak to someone who has drank too much in the past. I've never used illegal drugs, but I've definitely drank way too much in the past. So I hope that you're able to fix whatever the underlying problems were, if there were underlying problems. I hope you're able to do that, and also hope you're able to keep yourself clean. I hope you're able to do that for your own sake, as well as, of course, your family's sake. So that you can get past this and get through it, and come out the other side, as a better person. So I really hope that you'll be able to make it. I really hope that you can overcome your problems, whatever they are, address whatever underlying issues there are, and also keep sober. Those aren't quite the same thing. I hope you're able to do both. I wish you the best going forward. I hope you're able to pull this through. The Nick I knew a couple years ago when I visited his house was someone that I at the time considered myself a friend of. And I hope maybe someday in the future I can meet that person again. That would be nice. I hope someday in the future I can meet that person again. I really hope it will come together for you. I really do. So I wish you the absolute best. All right. I'm going to go ahead and sign off for now. I've been Uncivil Law. Hopefully this is the last of the Nick Rekieta streams on this topic. I'm happy to finally put this to rest. Hopefully this is the end of the saga. Until later, my friends, I wish you all well. Cheers for now, my friends, and goodbye.